Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon, barely, to those of you on the East Coast, and a warm hello to everybody in between. My name is Dan Balkaran, and I'm going to be your employment lawyer for the next half an hour, answering all of your questions about, excuse me, all things employment law. As you can see on the screen, I work for Samfiru, Tumarkin. I'm an associate at Samfiru, Tumarkin LLP, which is Canada's leading employee side employment law firm. As always, if you want to contact me or contact us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. All right, lots of questions rolling in today, so let's get right to them. Deborah asks, if I was let go from a private care home due to a vaccine status, am I still entitled to severance? Probably not. So the vaccine question, so it's an open question still in Canada if you can be terminated for zero severance for failing to be vaccinated. There hasn't been a legal decision on that particular point yet, which is kind of surprising. There has been a decision in BC only on what happens where someone is put on unpaid leave, the sort of temporary unpaid leave status for failing to get vaccinated. And in that particular case, the court found that, in fact, an employer could place effectively place an employee on an unpaid leave status indefinitely without it being a termination, without them being entitled to severance in the event that they did not comply, the employee did not comply with a mandatory vaccine policy. But the implication, or at least the language of that particular judgment and other arbitration decisions across Canada implies that it's a totally different animal if someone is terminated for, someone loses their job for failing to be vaccinated. So it's not, we don't have a decision on that particular point yet. We will get one. I suspect that termination is a bridge too far. Unpaid leave, probably something that is going to be upheld, but termination, no. However, we don't have a decision on that particular issue yet, and there are cases working their way through the courts. Now, specifically in your case, and why I said probably not, governments passed vaccine mandates. So the mandate question, the term is kind of confusing, and because employers have vaccine policies, which were called mandates, and the government also passed mandates. So just to clarify the terminology here, when the government said if you work in X, Y, or Z sector, you have to be vaccinated, and the provincial government said this, and the federal government said this in different subsectors of the economy, that's a mandate. When your employer does it, says in order to work at ABC company, you must be vaccinated. That's a vaccine policy. Okay, so that's the difference in the nomenclature. Nothing really material turns on it, but it'll help you understand. Now, governments across Canada said if you're dealing with vulnerable people, those in care homes, those medically vulnerable, such as hospitals, you must be vaccinated in order to continue maintaining your position, and you cannot work without being vaccinated. And that sort of was broadly applied even if you work from home, for example. You're a hospital worker, but you work from home. So what that does is your relationship is between you and your contractual relationship is between you and your employer. Okay. You give labor on an ongoing basis to your employer, who gives you money, and there are other terms bound up in that. What the government mandate does, it says you must be vaccinated. It comes in over top of it and just squishes the whole thing and says, well, listen, you, the employee, are now unable to give your labor in exchange for money because you're not vaccinated. And so through no fault of either you or the employer, neither party can complete its contractual obligations to the other, and therefore all of your obligations under the contract of employment that you have are obliterated. It's called frustration of contract, including your right to severance, which is an implied contractual term. And so no, because if you work for a private care home, there will be some sort of vaccine mandate, most likely, that covers you. I mean, you'll want to double check, and you can always talk to an employment lawyer. If you want to talk to us, you can certainly do so. Employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But there's most likely going to be a vaccine mandate that applies to you, which extinguishes your right to severance. And that's not moving from your employer, that's moving from the government. Okay. So, next question. One sec. Okay, Darlene asks, where we go? Okay, Darlene asks, can an employer make you sign a new contract if you've already worked there for 10 years? That's a great question. Great question. Okay, so let's talk about contractual first principles. In order for a contract, to have, I mean, really, first principle, a contract is just an agreement between two parties. Okay, and in order, there'll be often contracts, agreements between parties. There's disagreements about whose obligations are what to the other, and when can they get out of the contract, and all that stuff. And so for a contract needs to be enforceable. Okay, that means that you can, if there's a disagreement, you go to court, and the court says, no, party A, you owe these obligations to party B. Okay, and so in order for a contract to be enforceable, there needs to be fresh value at the time of contract formation that goes in both directions. Okay, so for example, Darlene, if I give you my bike for $20, we have an enforceable contract. You have the bike and I have $20. Yeah. If I then say, hey, I want my bike back, you can say, no, it's my bike, and the court will side with you because you give me $20 for the bike. But let's just say that the bike is worth $10,000. Okay, but I sell it to you for $20. It's a terrible deal for me. Do we still have a deal? Yes, we do, because the law doesn't care that it's a bad deal for me. We're free to enter into our own bargains. The law only cares about, do we have an enforceable bargain? And yes, we do, because $10,000 bike goes one way and $20 goes the other way. Now, what if instead of giving me $20, you give me zero, and I give you my $10,000 bike? I mean, realistically and practically, $10,000, sorry, $0 and $20 are basically the same as against a $10,000 bike. However, the law considers it, because you gave me zero, that in fact we don't have a good deal. You're just holding on to my bike for me, and it's still legally my bike. Okay, so fresh value has to go in both directions. And so why am I telling you about this? Well, in the bike example, it's a one-time transaction. Bike goes one way, $20 goes the other way, done. Parties never talk to each other again, and it's a one-time transaction. But in an employment situation, it's an indefinite transaction. And so on an ongoing basis, forever, until there's a change in circumstance, such as termination or quitting or what have you, you're giving your labor for money, right? That's basically what you're doing. You're exchanging your labor for money on an ongoing basis. Okay, and so if you sign whether or not you sign an employment contract, there are terms of employment, some implied, not implied, but imbued by statute, some implied by the common law, and others, can be written down in an employment contract that all govern your relationship, your contractual relationship. But the core is you exchange a certain amount of labor for a certain amount of money over a certain amount of hours, right, on an ongoing basis. And so the terms that you're working under, be they written on a contract or just implied into the situation, in order for the employer to change those terms, it has to provide you with, fresh value, again, because it's an indefinite relationship. It's not a one-time bike for money transaction. It's got to provide you with fresh value for changing those terms, materially changing those terms. So if it wants to add a termination clause to your contract where there wasn't one before, it can do that by providing you with a signing bonus. And I mean, the law is kind of fuzzy on this, but the signing bonus shouldn't be $1. It has to have theoretically, it has to have some weight, although the law is fuzzy on that, or a raise. but it's not a raise that you would normally get. It has to be a raise for signing the contract itself. Okay? It can also provide you, depending on what your situation is, it can provide you with the applicable amount of notice for making that change. But that's not something I think that we're dealing with here. Okay, so if they just say, hey, here, sign this contract, the question then becomes, are you getting fresh value for it? Now, fresh value can be very small. Okay, it can be, your vacation pay allotment increases, your title changes, your responsibilities change for the, in a positive way for you. It can be your commission structure changes. It can be your benefits change, wages. It can be all kinds of things. But if there's no fresh value change, no fresh value provided, then the contract isn't enforceable. But it's a tough one. It's a factual analysis. You'd want to get legal advice on that point. Where this matters for you, Darlene, is if you didn't have a contract before, and now you were there for, you've been there for 15 years or something, and now they're saying, hey, sign this contract with a termination clause. It could be that upon your termination, you go from having sort of a best day of 17 months of severance to 8 weeks. Okay, so it's a massive change that they're like a massive loss of value and leverage and bargaining power for you. So before you sign that contract, you 100% should talk to an employment lawyer and find out what the change in your legal rights entailed in you signing it is. Now, there might be none. You might have a previous contract that says something substantially similar, or it could be everything, right? Like if you're like 55 and you've been there for 30 years and you never had an employment contract and they're trying to give you one that limits your termination rights, you don't want to sign that contract. So you need to absolutely talk to an employment lawyer. Employmentlawyer.ca if you want to get a hold of us. Help at employmentlawyer.ca at 1-855-821-5900. And just as an aside here, for 99%, if not higher, of you employees out there, the employment contract is for your employer's benefit. It's not for yours. Because it limits, the purpose of the employment contract is to limit your rights as against the employer, right? So for certain high-powered individuals like CEOs who are very in demand and can negotiate, all kinds of things like golden parachutes, it might be different. But for most of you, it's for the employer's benefit. So if you've never signed a contract, great. Don't insist on it. I say to people all the time, like, I insisted on a contract. I'm like, why? You insisted on restricting your rights. That makes no sense. So if you're ever, just for any of you, if you're ever given a new contract or you're about to sign and start on a new job, it's worth it to talk to an employment lawyer. Find out exactly what you're agreeing to and what it actually means for you over time. Okay, great question, Darlene. Next question. No individual name here. Can a single instance of proven insubordination be enough for just cause for dismissal, or do you need to consider the severity of the insubordination and/or the employee's employment record? Whoever this is knows something about employment law. I think these were all like very nuanced points, and I think you effectively answered your own question. So there is law out there that says one instance of insubordination is certainly not sufficient. There is law that says that a single instance of insubordination, particularly in the context of sort of unblemished longer service, is not going to be sufficient for just cause, or at least it hasn't been in some cases. Right? The thing about just cause is there's no hard and fast rules. A lot of it just, what does the judge think? Does the judge like you? How did you comport yourself in the situation? To a large degree, but yes, you're right. A single instance might not be enough, but it depends on what you did, right? Like if they told you point blank not to, steal from the company, and then you did, well, that's different. That's theft. That'll get you out of there anyway, for just cause. But yes, it's the egregiousness of the insubordination needs to be evaluated. If it's, you've been there for 20 years and it's not really clear that you were given clear direction that you just ignored, for your own benefit, I think you probably are fine. But if it's something where you're given clear direction, particularly in your writing, and you transgress that direction anyway because it materially benefited you in some way, you could be in trouble, right? So, but as always, as you said, the employee's record matters, right? So if you have 25 years of unblemished service, there's this famous case in Ontario, and Ontario is more employee friendly than other jurisdictions, but there's this famous case, I think it was in Ontario, where a long-serving employee got mad and punched a coworker in the face and broke his nose, and that wasn't just cause. So because he had a long distinguished record. So whereas if you've been there for a year, you have a history of lateness and other issues, like it'll be just cause every time. So it's entirely contextual. I don't have your name. These are great questions. You already seem to have a really good understanding of the nuance of insubordination. However, I would encourage you to talk to an employment lawyer, employmentlawyer.ca, helpandemploymentlawyer.ca, 1-855-821-5900. Okay, next question. No name as well. If offers and statements was made and accepted on the same email, is it legally binding? And if the statements in the email were not met, could it be considered negligent misrepresentation? Which is also a legal term. I think a lot of you guys have been doing your legal homework, which is great. Okay, so first part of your question. If someone makes you an offer and you accept it, doesn't matter if it's verbal, doesn't matter if it's by email or in a formal written contract, it is binding. I mean, depending on the situation, provided that both of you have the capacity to enter into some sort of agreement, etc., both parties. So, but yes, I mean, if they say, here, we want you to start work for us on Monday, and we'll be paying you $30 an hour, and you'll be working full time with benefits, other terms to be provided, and you say, yeah, let's do it. Yeah, you have a job at that point. Okay. Now, yes, if they had orally, and I mean, it depends what's in the written contract, because a lot of written contracts will say if it's not in the contract, then it has no force and effect whatsoever on the four corners of your relationship, your employment relationship. But if they make oral or written representations to you that you relied upon to your detriment, then yes, that is legally negligent misrepresentation. The question is, did you suffer harm as a result of that? Right. And so that I can't answer by looking at your situation. But if it's sort of a minor thing, like, you were told your company car was going to be blue and it turned out to be silver, like that's not. But if it's something that caused a substantial material loss to you, that could be something. Right. So it depends. And just generally with a lot of potential legal disputes, the real question is, what is the potential harm? Or sorry, what was the loss that you suffered? Sorry, not potential harm. What was the loss you suffered? And it's the loss that sort of dictates whether or not you're going to want to advance your claim at all. So, okay. Let's move on. Art asks, started a new job in October. The employer made a lot of promises about the growth of the company. Now they said to let you go. Am I owed anything? So, kind of interesting. It touches on the representations issue. Second component. I was at my last position for 16 years, and I'm upset that they talked me into leaving, only to be let go. Okay, this is actually first of all, Art, I'm sorry to hear about that. The stuff about the prom. Okay, actually, I'll tackle this with the second part of your question first. So, if there's something called inducement in employment law. Well, the first question is, do you have a right to common law severance? That depends what's in your employment contract. Okay. If you don't have an employment contract, or you can get out from underneath the termination clause in the employment contract such that you get common law severance, you'll need a lawyer to look at your contract to evaluate that. Then in the evaluation of how much severance you get, there is a whole body of law called inducement that says, well, you worked at company A for 16 years, and then company B says, hey, we're going to give you more money. You're going to be here a long time, and there's an opportunity for growth here. Come on down and work for us. And you, based on those inducements, on those promises, you go work for them. I mean, it's not quite that your 16 years that you work somewhere else is added to your length of service, okay? Thus increasing your severance potential substantially. But it acts as like an elevating factor, we'll say. And so it's harder to prove. You got to hit all the factors correctly. There has to be true inducement. There is some thought out there that if the employment contract doesn't, has a probation clause at the new job, then you don't get it. Although I looked through recently, I looked through a lot of decisions on inducement, and I'm not sure that that's the case. I think that inducement doesn't just have to be anchored in, promises of longevity. It can be in, we're going to pay you a lot more, or you're going to be in a better position, or you have the opportunity to grow into a senior position, or what have you. So, Art, I feel for you. I'm sorry to hear about your situation. You didn't say it. I don't know if there's an issue with the new company B. Do they also not have any money? That's something you have to worry about too if you're bringing a legal claim. But Art, you need to talk to a lawyer right away. And when you talk to the lawyer, mention inducement, severance. They'll do the rest. Again, employmentlawyer.ca. It's right on the screen. Help@employmentlawyer.ca. 1-855-821-5900. But yeah, Art, you need to make that call immediately. You need to talk to an employment lawyer. Okay, Anna asks, I'm on the second round of an incident report. After filing the first one, my boss is retaliating on me. I have raised the issues of my general manager making racial comments, consuming drugs and alcohol in the job. He's trying to push me out. HR is investigating. What can I do to protect myself? Oh, okay. So if I understand this correctly, you made a report about how the general manager is making racist comments and consuming drugs and alcohol in the job. These are obviously very explosive accusations. And certainly I assume that you have something to substantiate that. And the human resources investigating. I mean, to the extent that you've put things, this is tough, right? Because, you're going to want to have some sort of paper record of these things. So you're going to want to email human resources and follow up with that. But your boss is retaliating against you. I mean, none of these issues, are the racial comments against you? In which case they can't get rid of you because that's they'd have you'd have a human rights complaint against them for that, which could be extensively problematic for them. I mean, you can talk. Are the drugs and alcohol consumption by the general manager a health and safety risk for you or others in the job? In which case, occupational health and safety legislation probably prohibits them from retaliating against you. But if not, it really comes down to what is your severance entitlement on termination, and then do these have sort of these factors? Retaliation has a expansionary effect on that, potentially. Maybe not expansionary, but certainly can assist with, we'll call it allocation, breach of duty of good faith. In terms of protecting yourself, I mean, you made these accusations. I think it's going to be very hard for you to continue to be there. If they want to keep that general manager, I don't know how this resolves itself out. So I don't know how much you can do to protect yourself now from losing your position, other than documenting everything with human resources, right? This one is really hard, Anna, and I think you need to talk to an employment lawyer right away. I think you need to have a lawyer really look at your nuanced facts and see what advice they can provide you, if any, to, depending on what your goal is, right? So you see on the screen, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900 if you want to get a hold of us. But a lawyer's going to have to go through your nuanced facts and then really look at, where are we at right now, and is there anything you can do to try to, what is your objective? Is your objective to get money on the way out the door, or is it because then, the lawyer can structure his or her advice to you around that? But is it not that? Is it that you're trying to stay there, and is that even possible at this point? If they've decided to keep the general manager, I mean, saying that your general manager made racist comments and consumed drugs and alcohol on the job are explosive charges. Now, if you don't have any evidence of that, then it's just sort of a he said, she said, and they might side with the GM, and you could be out. If you got evidence of it, I'd certainly present that to HR immediately, because then the company might have to act on the general manager. But I wouldn't do anything. I just sort of am speaking generally here, not knowing anything about your situation. You should talk to an employment lawyer immediately. Tanya asks, how long does it take to settle a work injury that resulted in permanent impairment? That's an occupational health and safety question that you have to direct to whichever tribunal deals with those matters. In BC, it would be the WorkSafe BC. A reasonable accommodation employer negotiates on, this is Tanya again, on causes. It negotiates and causes you to lose wages. What can be done? It depends on if the accommodation is reasonable with respect to your, so say you have a permanent medical injury, you can't work at the same degree before. There's an requirement, a human rights requirement for the employer to accommodate your injury to the point of undue hardship. It's not required to put you back in the exact same position, but may provide you with a reasonable accommodation. So if the answer is that it's found, I guess you'd have to make a human rights complaint, I think, on that one. But if it's reasonable, like you were making 100 cents in the dollar and now you're making 75 because of your injury, and that's found to be reasonable, then there's nothing you can do, right? So the answer is you'd have to file a human rights complaint, but again, you got to talk to an employment lawyer. That's going to turn on the facts to your situation. So employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Oh, lots of questions I'm not going to be able to answer today. Let's see how quickly I can get through these. Unfortunately, I have something at 10 o'clock, so I'm just going to try to answer the next two in a minute or so. My manager wrote, may have to proceed to a more permanent solution in the future after my escalated bullying issues to higher up manager, then received unjustified PIPs and terminated. Your thoughts? I think that it depends on how far apart the PIPs are, what the PIPs PIPs are performance improvement plans. Like if you have an ongoing, normal employment, then you complain about bullying and harassment, and then you get 2 PIPs and are fired in a month. Yeah, they're not going to be able to be successful in their just cause defense. But if this happened over the period of a year and the PIPs talked about the same things, like pattern of lateness, fired, then you have a much harder issue. You have a much harder road. And as always, it depends on your how long you've been there and what your record was like. So I sound like a broken record. You got to talk to an employment lawyer immediately. Just cause is it's contextual, it's factual. Employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. I don't think I can get to these questions because we're out of time. I'm just trying to see if there's one more I can do. LTC, I don't know what that is. Employees were not getting severance for forced unpaid leaves for refusing the vaccine. Are they getting it yet? No. And the only decision we have in Canada is the BC decision that says unpaid leaves are legal. Long-term care. I see. Long-term care. Yeah, no. As I answered this question earlier, I don't know if you got a chance to hear it, but certainly play back the video later. The first question I believe I answered was on this question. It's long-term care. No, it's covered by most likely by a vaccine mandate from the government. There's just no chance that you'll get severance when there's a vaccine mandate because the government extinguishes your right to severance. So, okay, that's it. I'm sorry, Baba, I couldn't get to your question about licensing. If you join us on Monday, most likely, is it going to be Chris? It's Chris Justice on Monday, March 6th, 1:30 Eastern. Bubba, if you come back in, ask that question. It's a complicated one, and Chris will get it for you, answer it for you. Again, as always, if you need to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. I'll be back in 2 weeks, again on Friday. And thank you all for joining us. Thank you for the great questions. Those are really great questions. Have a wonderful and safe weekend, everybody, and we'll see you soon.